School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Presenting Block 1 Overview of Business Law, Unit 2 Concepts and Principles, Part 1.
After completing this unit, you should be able to understand important concepts under business law, appreciate various principles under business law, explain the statutes that fall under business law in India, and discuss the methods for dispute resolutions, including alternate dispute resolution, that is ADR. Introduction. Law has become an important part of any business activity. Business law has taken an important place in the legal study. Business law provides legal and regulatory framework for doing business. It includes study of legal compliances related to any business activity. This unit will elaborate the concepts that fall under the business law. It will discuss the various principles of business law and the statutes that fall under business laws in India. The unit also examines the dispute resolution mechanisms for resolving business disputes, including the alternate dispute resolution mechanisms. Business law incorporates into its ambit the set of laws that directs the process of formation and continuance of business, setting forth the laws which establish the rules that the companies and enterprises follow. All legitimate businesses need to operate within the framework of the law. It is essential for persons working within the business world to have an understanding of how law works and affects their businesses. For example, a contract will only be of value to a business if it is legally enforceable. The law sets down rules for the setting up and administration of certain types of business and governs areas of employment of staff. Although specialist legal advice is usually obtained on specific legal issues, and it is essential to understand the core principles of business law. The enactment of laws and their staunch governance is of utmost importance in a country. Laws are rules and regulations which govern the activities of persons within a country. They provide necessary rules and balance the various interests of different members of the community. Both natural persons, that is human beings, and legal persons, that is companies, are bound by laws of the country they reside in. From these laws, they can ascertain what they are permitted to do and what they are not permitted to do. Concepts under business law. Any business begins with the basic understanding of what has to be done under any particular business and in what form it has to be done. A business may be established for production, manufacturing, provision of service, or sale or purchase of products. Every such objective involves a complex set of contracts, transactions, and payments. Similarly, in what form business has to be done requires deliberation about the type of business organization through which the business will be conducted. The types of business organizations would begin from sole proprietorship, in which an individual carries the business, followed by traditional partnerships, limited liability partnerships, and incorporation of a company. Doing business in Hindu undivided family, that is HUF, is also prevalent in India, in which male members of the family become co-partners in the business by birth in the family. The business is conducted by the karta of the family. Therefore, some concepts become more important for any entrepreneur to understand. These concepts are: number 1, whether the business involves sale and purchase. If yes, basic concepts relating to contracts of sale should be well known. Number 2, whether the business involves production or manufacturing. If yes, basic concepts relating to the contracts, intellectual property, product liability, contractual and tortious liability should be known. Number 3, whether the business involves formation of a partnership. If yes, depending upon the type of partnership, the process of formation and forthcoming liabilities of all partners should be very well known. In traditional partnerships, registration is not mandatory but has serious consequences in reducing remedies for the partnership against third parties. Partnership deed is advisable to be prepared as such partnerships have unlimited liabilities of partners. Limited liability partnerships or LLPs provide opportunity to enjoy the benefit of partnership with limited liability of partners through incorporation of LLPs. Number 4, whether the business involves incorporation of a company. If yes, which type of company will be suitable for the business should be understood. Generally, a limited liability company should be constituted for business involving capital and financial risk. Rights and liabilities of shareholders of companies should be well understood for both private and public limited liability companies. Number 5, whether the business is capital intensive. If yes, it should be known how the capital would be raised through public issues or borrowings. Number 6, whether payments are required to be made. Generally, all businesses will require payments to be made to different persons. Basic knowledge about the concepts of negotiable instruments is required. Number 7, every business involves different types of risk. Concepts relating to the insurance and risk management should be known, and accordingly risk should be insured through proper insurance policies. Number 8, disputes are also a part and parcel of doing any business. Concepts relating to the rights, remedies, dispute resolution, including alternative dispute resolution mechanisms, should be well understood. And number 9, legal and regulatory compliances should be properly adhered to by all businesses. For example, if business makes profits, how to comply with tax liability. If business involves offshore transactions, then how the tax liability should be covered becomes important for any business. Principles of business law. Number 1, law and morality. The Natural Law School of Jurisprudence postulates that the law is based on what is correct. Natural law philosophers emphasize a moral theory of law, that is, law should be based on morality and ethics. Natural law is discovered by humans through the use of reason and choosing between good and evil. The very efficiency of the legal system depends on the moral attitude towards the notion of legality, since conformity without the law is not in itself a legal matter but a moral obligation. Every law can be and should be evaluated from a moral viewpoint. The law cannot and must not regulate every aspect and each moment of our lives. Most often the law tells us how to proceed but not what we should do. Thus, businesses also have moral obligations, and the business law acts as a guiding force to fulfill these moral obligations. Morality is achieved by following the law not only in letter but also in spirit. Number 2, business ethics. Business, being part of the society, has an assortment of responsibilities. Businesses have a relationship with the other parts of the community, such as consumers, workers, vendors, marketers, etc. Businesses owe responsibility towards these parties of the community. The degree of responsibility may vary from business to business or stakeholder to stakeholder. Responsibilities are of diverse nature, such as safe working conditions for the employees, good quality products, profit maximization for the shareholders, and sustainable use of the society's resources. Ethics is the study and practice of decisions about what is good or right. Ethics guides us when we are wondering what we should be doing in a particular situation. Business ethics is the application of ethics to the special problems and opportunities business people experience. An ethical dilemma is a problem about what a firm should do for which no clear right decision is available. At the same time, the business ethics guides decisions within firms and ethics helps guide the law. Law and business ethics serve as an interactive system, informing and assessing each other. The principle of contract law, for instance, facilitate market exchanges and trade because the parties to an exchange can count on the enforceability of agreements. Legal rules that govern the exchange have been shaped in large part by our sense of commercial ethics. The law dictates how a person must behave. Any choice about how a person should behave that is based on a sense of right and wrong is an ethics decision. Laws represent society's view of basic ethics rules, and most people agree that certain activities such as murder, assault, and fraud are wrong. However, laws may permit behavior that some feel is wrong and it may criminalize acts that some feel are right. Similar situations arise under business law. For example, Factories Act 1948 permits employment of children above 14 years of age. This may be wrong for some people, however, it has been permitted under the law to allow them to earn a living according to the provisions set out in the law. Number 3. Common law. Common law has been a major source of developing business law. Earlier, commercial law was not regulated through specific statutes. Rather, the principles of equity and justice were adopted in the common law approach, where precedents acted as a guiding force. Thus, common law still plays a very important role in the evolution and enactment of commercial law. The term common law has several different meanings. It is usually used to mean the law that is not the result of legislation but is the law created by the decisions of the judges. When common law is given this meaning, it encompasses cases that have used both or either equity and common law. English common law was law developed by judges who issued their opinions when deciding cases. The principles announced in these cases became precedent for later judges deciding similar cases. The English common law can be divided into cases decided by the law courts, equity courts, and merchant courts. The common law is a beautiful system containing the wisdom and experiences of ages. Like the people it ruled and protected, it was simple and crude in its infancy and became enlarged, improved, and polished as the nation advanced in civilization, virtue, and intelligence. Adapting itself to the conditions and circumstances of the people and relying upon them for its administration, it necessarily improved as the condition of the people was elevated. The inhabitants of this country always claimed the common law as their birthright and at an early period established it as the basis of their jurisprudence. Number 4. Natural law. The term natural law refers to the idea that there are certain ethical laws and principles that are morally right and above the laws devised by humans. This concept suggests that individuals should have the freedom to disobey a law enacted by a majority of people if their individual conscience goes against the law and they believe that the law is wrong. The idea that people have basic human rights, for example, is rooted in the concept of natural law. The natural law school of jurisprudence postulates that the law is based on what is correct. Natural law philosophers emphasize a moral theory of law, that is, law should be based on morality and ethics. Natural law is discovered by humans through the use of reason and choosing between good and evil. The law must have a moral basis. Where do we find the moral basis that would justify a law? Aquinas says that good is that which all things seek after. Therefore, the fundamental rule of all laws is that good is to be done and promoted and evil is to be avoided. This sounds appealing but also vague. Exactly which laws promote good and which do not? Is it better to have a huge corporation dominate a market or many smaller companies competing? Did the huge company get that way by being better than its competitors? There can be numerous examples of the natural law theory to business laws, as business laws have evolved over time through customs and general usages which were considered as the rules of the trade. These rules were based on ethical conduct, equity and fairness, which has been ingrained in the laws by the law-making bodies. Number 5. Contractual principles. Salmon has defined a contract as an agreement that creates and defines obligations between the parties. Section 2, Clause H of the Indian Contracts Act 1872 defines the term contract as an agreement enforceable by law. This also means that a contract is fundamentally an agreement having the power to legally bind the parties. A contract is an agreement that is enforceable by a court of law or equity. Every contract involves at least two parties. The offeror is the party who makes an offer to enter into a contract. The offeree is the party to whom the offer is made. In making an offer, the offeror promises to do or to refrain from doing something. The offeree then has the power to create a contract by accepting the offerer's offer. A contract is created if the offer is accepted. No contract is created if the offer is not accepted. All business laws have an element of contractual relationships which are governed as per the law. The Indian Contracts Act specifies the essentials of a valid contract, also stating the various provisions that govern its enforceability. Simple transactions such as purchase of goods and services is a contract which attracts various statutes under the business law. Number 6. Equity and fairness. Equity and fairness is an important principle of business law. The provisions under business seek to provide equitable treatment to all. There are laws which vary according to the size of the business organization or the nature of business activity, thereby differentiating between the business and the laws applicable to them. One such example can be the provisions of corporate social responsibility, where the amount of contribution by the companies is divided by thresholds on the basis of turnover, net worth, or net profit, thereby putting more responsibility on the bigger companies.
We were listening to the audiobook by the School of Management Studies, IGNOU, for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.